if you like and pull up the operating agreement so you can see the language if that will help.
Okay.
But I guess you'll have to allow me to do that.
Let me see. I'm having some issues here with getting that done. Let's see. Um, so I'm sorry, you're not going to be able to share screen. So
That's okay. I can just read the pertinent portion of the
that's
operating agreement.
that's fine.
Okay, and it is, I
And
think,
I've read all this just so you know. So
okay, and
if
I did
you
submit this to the court with a copy of this in a binder last week, so you should have it as well. But
okay.
essentially, 9.3, which is on page 11 of the operating agreement, states that expenses of each company agent indemnified or held harmless under this agreement that are actually reasonably incurred with their defense may be paid by the company in advance of the final disposition. If authorized by a vote of the members that are not seeking indemnification and holding a majority of the voting interests. So they are 50-50 partners. At the time that my client made her demand for advance payment, there was not a majority voting available to either deny or grant this advance payment. So and we have cited in our briefing, Sant versus Engineering Maintenance Corp. It's a 2017 case out of the appeals court that says when a company is unable to make a decision and regarding indemnity, courts favor it. And here we also think it's up to the court to decide whether or not our client is entitled to advance payment under this agreement. The other requirement is that she has to submit in writing her good faith belief that she has met the standard of conduct necessary and will agree to repay any applicable expenses if it's ultimately determined that she didn't act in good faith. Well, she's done that. So I'd also just like to tell the court that because it is up to the court in this scenario, one of the reasons I believe the court should grant it because it is favored. We've also cited In re de Mattia, which is a 2022 Dallas Court of Appeals case that essentially says that it has analyzed a lot of cases where advancement has been requested to the courts, and the courts favor, again, advance payment because they want to encourage corporate people to become corporate officers without fear of being sued and having to front the litigation expenses. And we have cited in our briefing a response from the defendants. I'm going to read this because this, I think, should also help persuade the court that Kristen Coughlin should receive advance payment. When she tried to withdraw from the company early on, we received a response from opposing counsel that just said there will be no indemnity by L. Resnick or Peak, and there will be no payment of professional fees. Further, Kristen, our client, needs to understand that in the case of a withdrawal, the lawsuit will continue and the pace and extent of litigation will increase. Additionally, Kristen should be aware that whatever entity she attempts to start next will be made part of the lawsuit. Perhaps it is time for her to realize that this is only going to get more expensive for her to litigate and deplete more of her funds. The more advantageous thing for all would be to get to work to get Peak financially healthy and sell my client's interest to a third party. So the plaintiffs are essentially using the threat and expense of litigation in order to intimidate my client, who is entitled to advance payment. Moreover, she is no longer a member of the company. She withdrew under the operating agreement. There is no non-compete. She's not bound by any of that. So what they've done is they've threatened to sue, and they have sued her current employer, and any other entity that she tries to go to work for is going to be subject to this lawsuit. So they're using the threat and expense of litigation in order to intimidate and try to keep her working for the company, which she did not want to do. Again, so with it being up to the court, we believe that this should help sway the court along with the case law that we cited, that advancement is favored and she is entitled to receive advancement of her attorney's fees while the outcome of the case is pending. And if ultimately the jury decides that she's not entitled to this, she will pay it back as she has indicated in her filings and as she's made clear. So that is what we're seeking summary judgment on, is advancement. And then we've also, the plaintiffs have sought summary judgment on our indemnity claims, saying that we are not entitled to indemnity. And again, under the operating agreement, it discusses indemnity and says that the company does have the power to defend and indemnify any person who is or was a party or threatened to be made a party to any proceedings. There is a second section that says mandatory under the indemnity provision, and it says the company must defend, indemnify, and hold harmless a company agent in connection with a proceeding in which such company agent is involved, if and to the extent Texas law requires it. Well, we submit that Texas law does not require indemnity. So again, that's going to be a fact issue. This agreement does not specifically prohibit indemnity. It says you're entitled to it to the extent you are under Texas law, and we believe she is entitled to it, but it's a fact issue. And so we think that you should deny plaintiff's motion for summary judgment on indemnity claims. Okay, and that's all, Your Honor.
Okay, response?
Good morning, Your Honor. Patrick Huron on behalf of plaintiffs. Let me begin by first objecting to the statement that Ms. Burns referred to. That was a hearsay. It was attached. Also, it was not part of her affirmative summary judgment. That was attached to a response to our summary judgment. So she didn't make that argument or present any of that hearsay evidence. It's not evidence. It's not been authenticated to or proven up under any exception to the hearsay rule. So I would just object to that on the front end of this. Your Honor, the only other sort of preliminary statement I would make is that I plan to address defendants' argument about their summary judgment on advancement. They did not, as Ms. Burns acknowledged, did not ask for summary judgment on indemnity. So I'm going to address their argument, and then if the court allows, I would then like to go into plaintiff's affirmative summary judgment, which addresses both indemnity and advancement. Your Honor, with that in mind, start with the law. And under Texas law, for limited liability companies such as Peak Solutions Group LLC, which is the entity at issue and the operating agreement at issue, for LLC, indemnity and advancement are not mandatory under Texas law. And you find that, Your Honor, in the Texas Occupation Code, Business Occupation Code, section 101-402, which says that LLCs may indemnify or pay advancement. And then that is supported by section 101-052, which then says the company agreement is what governs this relationship between members and between the entity and members. So with that, Your Honor, you turn to the operating agreement because Texas law doesn't mandate advancement. Now, and frankly, Your Honor, defendant Coughlin has not cited any authority that says that advancement is mandatory, at least any binding authority on under Texas law. It seems to me that both parties agree that the issue is governed by the language of Peak's operating agreement. And of course, just as a front end of this, Your Honor, when analyzing an indemnity or advancement provision such as we are doing here, the court applies the normal rules of contract construction. So if a bylaw is written so that it can be given a definite interpretation, then it is not ambiguous and the court will construe it as a matter of law. And the trial court must focus on the language used in the contract, because that's the best indication of the party's intent. And that's a cite from the Ryan's insurance case out of Houston, Honor, and picked up by Texas Supreme Court case law. The one that we cite is Coker versus Coker. And the court must enforce the contract as written. I mean, that's sort of what we all know is the contract construction rules. So with that, with regard to advancement, defendant peace operating agreement does not mandate advancement. It's that simple. It permits advancement, but only when that advancement is authorized by an approving vote with a majority of members who are not seeking indemnity. And here, as is evidenced by the testimony from my client, Ms. Resnick, the Peak did not authorize advancement for Ms. Coughlin in response to her request. I do want, I don't know if something to share, I do want to point out this is
I'm sorry, I just want to state for the record, Mr. Carew, you're kind of going in and out, so I'm not getting, some of your things are garbled. I just want you to know for your record.
Thank you, Ms. Rager. I'll try and slow down and maybe that will help.
Well, it's not that, it's something wrong with the computer. It's just kind of like going in and out. Just letting you know.
Okay. Okay, thank you. All right, just turning back to the operating agreement. Ms. Burns read a section 9.3, which is the section of the operating agreement that addresses advancement. But I think conspicuously absent from that, and what she left off was the controlling clause, that language of that provision. She literally stopped reading where it says, excluding the voting interest of the company agent, and it's here, that would be her client, excluding the voting interest of the client seeking indemnification. So the provision is very straightforward. Peak authorized advancement if it's approved by a vote, and that vote is comes from the members that are not seeking indemnification and which hold a voting majority interest. And when you consider that, when you calculate that majority, you exclude the interest any members who are seeking indemnity. Now, as Ms. Burns points out, and as their papers submit to the court, her client has already withdrawn from the company. Her client does not have a voting interest in Peak. It did not have a voting interest in Peak at the time that Peak considered and voted on for a request for advancement. So the evidence in front of the court is my client's testimony that they considered the request and that she voted to decline it, and therefore Peak did not authorize advancement. That's the sum total of the argument, and that's the only evidence the court has before it. It's uncontroverted in her papers. So Texas law allows those restrictions under the CBOC 8003. It says that LLCs may adopt provisions regarding indemnification, and that if the company's operating agreement or bylaws does that, then those are enforceable. And here, that's exactly what the owners of Peak at the time they formed this agreement. It's what they did. They set out a procedure by which advancement would be considered and voted on and either approved or disapproved. As to the authorities cited by and relied on by Ms. Coughlin in her papers, first, it's not at all clear that Delaware law mandates advancement. She cites to Texas cases applying Delaware law, but even that's not really clear. We cited back to some Delaware cases that say, like Texas, that it's really controlled by and governed by the underlying bylaws and the contractual agreements between the parties. And second, defendants' authorities are entirely distinguishable. So, for example, the In re Dematia case, and we would agree that's sort of a landmark case right out of the Court of Appeals of Dallas. In that case, the underlying bylaws mandated advancement and indemnity. It's literally said shall indemnify, shall advance. In that case was about whether a particular claimant qualified under that division. It didn't find that indemnity is mandatory. They simply applied the language of the agreement which mandated it, and then they analyzed whether the person who was requesting advancement was entitled to it. And that's true for the Delaware cases and the other Texas cases that we cite at footnote 3 in our response to their summary judgment. Lastly, Your Honor, they cite no authority to this court for the proposition that because of some tortured disagreement between the parties, that the court can step in and decide whether advancement should be provided or not. What she says, what they argue, Your Honor, is that, well, because both Resnick, who's the current 100% owner, and because Miss Hoagland, who used to be a 50% owner, are both parties to this lawsuit, and because they're in a disagreement about this particular issue, the court has to step in and decide that. And they don't cite any authority for that. And that ignores the express terms of the agreement that the parties bargained for when they formed Peak. And what we have in front of the court, the evidence is that Coughlin withdrew. That's part of her affidavit that she submitted to the court. She withdrew, and she has no voting interest. Resnick is the only member of Peak. That's cited in her testimony in paragraph 1.
You've already said this there, so let's move on to the next argument.
Okay.
I get it that she's withdrawn.
Okay. And so there's really just no authority for the court.
Do you have anything? Oh, okay. All right. Let me hear from you. Do you have anything else?
Are you asking me? Sorry, you broke up there, Judge.
Sorry, do you have anything else?
Yes, Your Honor. Just briefly, going back to the operating agreement, it seems that we all agree that the operating agreement controls. And again, it's at a minimum, it's ambiguous, but it says that a majority of the voting members not seeking indemnification, there's not a majority. There's only 50%. At the time that my client made the demands, and at the time that it was denied, there was not a majority voting interest remaining because they were.
So when you look at this issue, do you look at the time the demand is made, or the time it doesn't make a lot, because you're not supposed to be looking at your client's interest, right? But the agreement does.
Correct.
Correct.
Okay. All right, I'm going to take this to advice, and I'll take a look at the binder with your decision in the next 3 weeks. Okay.
Thank you,
Your Honor. And so are we now to plaintiff's affirmative summary judgment?
Yeah, I've reviewed that too. I've heard the argument. I'll review that and let you know in 3 weeks. Okay.
Okay, very good.
Your Honor.
Thank you, Your Honor. Maybe we'd be dismissed.
Yes, you may. You have a great rest of your day.
Thank you.
All right, Rhonda, what's the next case? Rhonda, what's the next case?
Sorry about that, I was muted. Next case is Verver Duct Pitch versus Sinart Kim. Cause numbers DC 23-11394. Attorney Chu and MacArthur.
Good morning, Your Honor.
All right, good morning. Is opposing counsel here?
Yes, good morning. Marilyn Wells on behalf of the defendant.
All right, and I understand that this case is set for trial tomorrow. Is that correct?
Yes, Your Honor.
That's correct, Your Honor.
And you guys are number one on the docket, just FYI. So, what is, and I guess the defense attorney wants to withdraw. Is that right?
So we had filed a motion to withdraw and a motion for continuance. We are wanting to move forward with the motion for continuance today, and not the withdrawal, Your Honor.
Yeah, we're not opposed to withdraw. This is the second time they brought it to my attention.
What do you mean?
Well, last year we had some depositions scheduled, and he said, "Oh, we're withdrawing from the case." So we went ahead and took those depositions off, and then they said we're not getting off. This time they're saying we're getting off. So I just don't know what's going on. But if they're not getting off, then we're ready for trial.
All right, Ms. Wells, if he's ready for trial, so what's going on?
So we have had, over the course of this, really difficult time communicating with the client. We were finally able to, have a meaningful discussion and communication, last week with him. So that's why we're no longer moving forward with that withdrawal, but we did announce that we are not ready for trial for tomorrow. We do believe that, there's not sufficient time, in order for us to get a certified, translator for the client. And to present the case, I believe that Mr. Chu has a conflict in the morning tomorrow as well. So we were just requesting a new trial date.
Mr. Chi, do you have a conflict?
I have a federal rearrangement and a plea that's set with the federal court tomorrow morning. We should be done first thing in the morning and be ready in the afternoon.
Is this a bench trial or
Bench trial. It's my understanding.
Rhonda, is this a
Yes,
bench
Your
trial or a jury trial?
Of course.
I'm sorry, Judge, let's see, this is a,
So this is a confirmation.
ma'am, just a minute, just a sec, hello. This is a bench trial.
All right, have y'all been to mediation?
I don't think so, Your Honor. But
That
I'm
also
sorry,
goes back to
we did
the
go. I'm sorry, Charles Oliver. We did do mediation. Yes, sure, we did do mediation.
All right. And Mr. Chu, I mean, I don't mind trying this tomorrow or later in the week, or you guys, I'm pretty flexible. So if Mr. Chu and I could also reset this to March 11th. What are your thoughts?
My preference is to get this over with tomorrow afternoon. It's short presentation on our side.
Ms. Wells?
Our request would be to reset to March 11th, again, just in order for us to fully prepare and be able to get a translator.
What kind of translator do you need?
It's
So our
Cambodian.
client is from Cambodia.
Are there Cambodia? I think I've had a Cambodia translator before. Have you spoken to one?
We have spoken to one for a deposition, but I believe the issue was that they were not certified. So we have been having issues finding a certified translator.
Judge Hoffman, I don't believe there is a certified Cambodian translator in the area. I have no objection to getting AT&T on a translation line under these circumstances.
Ms. Wells?
Yes, Your Honor. Again, we're just requesting continuance.
Okay, all right. I guess I'm not being very clear. Let me be. I need to know if the only basis you've given is you haven't been able to find a translator, but you haven't said kind of what you've done, what translators you've talked to. This case is set for trial tomorrow. The translator you used before, I guess, are you opposed to her using that translator even though they're not certified, Mr. Chu?
No, Your Honor, I'm not.
Okay, so why don't you get that translator on the phone, Ms. Wells?
Will do.
Why don't we put you guys on hold while she's doing that? And Rhonda's the next case. You guys just, Ms. Wells, just go ahead and mute and then let us know when you get the person on the phone so we can figure out their schedule for the week.
Yeah, can I have 5 minutes while we're doing that?
Okay.
What do you
Next-
need 5 minutes for?
Just take care of something, but I'll sit here and wait, no problem.
Okay. All right. What's the next case?
Next case is Ismail Hawkins versus Suk Young Kim. Cause number is DC 23-17071. Attorneys are Azani and LeBlanc.
Yes, Your Honor. Jonathan Blanc for the defendants here.
And Jordan Vore on behalf of the plaintiff and with the law firm of Andre Anziani.
All righty. Tony, did you get that?
I did. I'm sorry.
All right, let's do let's go on the record. Ron, go ahead and announce the case then.
Yes, the cause number is Ismail Hawkins versus Suk Young Kim. Cause number is DC 23-17071.
Okay, let's proceed.
Your Honor, Jonathan Blanc for the defendant. We filed this no evidence motion for summary judgment. This is a car wreck case where there are two causes of action: negligence per se.
Right. I've read all of it, so let me just kind of get to what my concern is. What I couldn't, maybe there's some issue with what was scanned in. Was there an affidavit filed by the plaintiff in this case? I didn't see it attached, but you referenced it in your briefing, Mr. Defense Attorney. I'm sorry, defense attorney. But I didn't see it attached. Was it attached?
It was attached to the copy we received. It was attached to the copy we received.
Okay. So I haven't seen what is exactly.
I'm sorry, Your Honor, you're cutting out. I'm not. I didn't hear any of that.
I think he disconnected. This is the first time I've seen.
Yes, I think the judge is offline.
Yeah, whoever Jack is. Oh, he's got host now.
Okay.
So.
All right, sorry about that. I'm having a lot of issues with my computer and my internet right now.
Your Honor, you're not alone, Your Honor. I had the same issue last week. My internet went out and I was dropped from like 3 depositions. It was very brutal.
Yeah, yeah, I'm having the same issue in my. So anyway, can you read to me the affidavit, because it wasn't, at least in the version I saw, I couldn't find it at least. What does the affidavit say about how the accident occurred?
Your Honor, did you get our reply brief?
Yeah, I did, but that's not what I'm asking about. I'm asking about the affidavit. So you got a copy of the affidavit? Can someone read to me what the affidavit said about the accident?
Your Honor, are you referencing the affidavit from the plaintiff, Ishmael Hawkins?
Yes.
I have it pulled up right here, Your Honor. I'll read it verbatim to you.
Okay, just the part about how the accident happened.
On August 27th, 2022, I was involved in a car wreck with a person who would later become known to me as Suk Young Kim in Dallas County, Texas, on the Dallas Parkway at or near its intersection with the Dallas North Tollway. While driving at that location, Suk Young Kim struck my vehicle from behind violently and without warning. There was nothing that I could have done to avoid the collision. Suk Young Kim's vehicle impacted the rear of my vehicle with the front of her vehicle. After the collision, we steered our vehicles off the highway and stopped at a safe location where we called the police. The police had us exchange information, but they did not prepare a crash report to my knowledge. As a result of this collision, I suffered injuries to my neck, back, left shoulder, right shoulder, and both arms. These injuries required medical attention and treatment. And as a result, I have incurred medical expenses for the treatment of my injuries.
Okay. All righty. You said, so, okay, I didn't see it in the filings, but apparently it was sent. So let's go ahead and response to that. You said you wanted to say something about the reply.
Yes, Your Honor. So we have objections to their evidence. First off, to the interrogatories, which are not verified, and then exhibits 4 and 5.
That's your client's interrogatories, right? Why aren't they verified?
I don't know why the verification was not attached, Your Honor.
I mean, they're your client, right?
That's correct, Your Honor.
You can't use that as a sword. I mean, you should have it verified. There's no justification for that. So you need to get those verified.
Okay, that's fine, Your Honor. But regardless, the interrogatories help our case. They don't hurt it, because our client says in the
Right.
interrogatories that she wasn't at fault. She was sideswiped. The same thing she said in her deposition in this case. Her deposition was taken in this case. We haven't been able to take the plaintiff's deposition because he's in prison, and we've gone through several notice of non-appearances to get it. But going back to the affidavit, the only evidence they have in this entire case is the affidavit, and it's paragraphs 3 to 5. And all they say is the general location of where the impact occurred. That's not
Well,
evidence.
he just read that they were rear-ended, correct?
He said it happened in the rear. This accident was not a rear end accident, as the police narrative said, and the property damage photos show. It was a side swipe that occurred in the rear of the vehicles. So his vehicle, as the police narrative says, changed lanes from the left to the right, and his left side rear impacted the front left side of
Right,
my
but
vehicle.
maybe I misread it. Read the affidavit again where it talked about. I thought it said that it was struck to the rear. Did I miss it?
Yes,
Hear
Your Honor.
that?
I will read it again, Your Honor. While driving at that location, Suk Young Kim struck my vehicle from behind violently and without warning.
Okay.
There was nothing I could do there was nothing that I could have done to avoid the collision. Suk Young Kim's vehicle impacted the rear of my vehicle with the front of her vehicle.
Right. That's just the general location of where it occurred. That's not evidence of negligence in of itself at all. Simply stating where the impact occurred and where the property damage occurred is not evidence of negligence. And the other thing I do want to put on the record note is that there were two causes of action, negligence and negligence per se. There was no attempt to defeat negligence per se in the motion. He says he filed a minute petition. I haven't seen the minute petition. I looked online on the docket and haven't seen the minute petition. So that cause of action is still live as of this hearing, to my knowledge.
All right, I'm going to deny the summary judgment. My understanding is the negligence per se was withdrawn. Is that correct?
Your Honor, that is correct. And if it has not been filed for, or if it was submitted and rejected for whatever reason, we will make sure that we take care of that, and that's removed from our pleadings to assuage Mr. LeBlanc's concerns.
Your
Okay.
Honor, if I do have another question. This case is coming up for trial in May. The plaintiff is in prison. We've tried multiple times to get his deposition. We can't get it. Is there a way to take this?
Yeah, so I mean, I've taken depositions when I was in private practice in prison. There's ways to do. You just need to contact the warden, and he can be
Your Honor,
deposed.
Well, we've
Honor,
asked the plaintiff's lawyer to do that for us, and they're not willing to do it. I mean, I can't contact the plaintiff directly. He's represented by counsel.
Your Honor, if I may just point out something about this, our client was previously being detained at the Fulton County Jail, and has since been transferred to the Georgia Department of Corrections. And
like in Georgia, as in Georgia, the state of Georgia.
Yes, Your Honor.
Okay,
and so,
I don't know how that works in Georgia. I've done Texas, so
I don't either, Your Honor. But I will say that it is pretty well established. The Fulton County Jail is one of the worst in the country. But the Georgia Department of Corrections has been a lot more forthcoming. We've never even been able to get a hold of someone at the Fulton County Jail. Like, they won't respond to our phone calls or emails or anything. But the Georgia Department of Corrections is a lot more responsive. I think that to address Mr. LeBlanc's concerns about getting the deposition, we will probably have a lot more success in that regard now that he's been transferred.
Okay, so do you know where he is now?
Last time we checked, when we filed this response, he was he was sort of in limbo at like the holding facility as they're trying to figure out which facility they're going to send him to. I have not received an update since then. If he's been but they told us that he would shortly be moved to a different facility. We'll continue to check in on that and let council know when he does get transferred. But we have no control over the Georgia Department of Corrections or what their policies are, and I don't practice law in Georgia. I would feel
Okay, so let me just kind of you have an obligation to produce your client. If you
Yes, Your
want to
Honor.
pursue this case, you need to produce your client. You need to make affirmative efforts to try to get him deposed. The defendant has the right to depose him. I've not dealt with Georgia before, but I feel like you kind of see this as like, oh, I can't do anything. You're an attorney. You should be able to do this. If there's an issue that you need the court's help with, in terms of issuing an order or subpoena, you may need to contract with Georgia counsel to get you your assistance. I don't know, but you can't just sit on your hands and do nothing. You've got to get this done, or the case is going to get dismissed eventually. So you need to take more affirmative action here to get this done, and not just sit on your hands. And so it's your responsibility. It may be difficult. It may be, and if need be, we could have a hearing before me, and I'll contact the sheriff's office. Do you have a prisoner number?
Yeah, and I apologize, Your Honor. I didn't mean to indicate that we were sitting on our hands. What I was trying to indicate was that I feel more confident now that we'll be able to get the deposition. That we're going to get a lot more cooperation from the Department of Corrections than we were from Fulton County. Which, again, no matter how many times we called or messaged, they never responded to us. We couldn't get a hold of anyone there. The first time I called the Georgia Department of Corrections, I was able to get a hold of someone. They explained what was going on to me and kind of gave me a brief timeline. Our client should be in where he's going to be either by late this week or like early next week. So we can get that. We'll be able to, if not today, shortly get that deposition scheduled. I'm hopeful of at least. Again, I've never taken a deposition cross state lines in a prison, so I don't know. I can't say for sure, but I that's my hope, at least my my thought process.
All right, defense counsel, I understand your frustration on this, and you have a right to take the deposition. What I would suggest, I mean, not suggest, but one way I've seen this done is you may want to move to compel the deposition and kind of put the plaintiff to his word here that he's going to get this done, because you do have a right to do that. It may turn out you have to go to Georgia to take the deposition, but if they don't have some type of Zoom type proceeding, but that's not anything I can do about right now. You need to kind of force the situation. Does that make sense?
Yes, Your Honor. Is there a way we could have the trial taken off the docket for May?
Nope, not yet.
Okay. Had to try.
Yeah. I mean, let's see what happens. It may turn out you can get him deposed, and I don't know. I mean, I will tell you, for Texas prisons, I've done this multiple times, both in private practice and as a judge, where we've been able to get a prisoner deposed or witness statement taken or gotten him here to the courthouse. I mean, this is not an impossible thing. Now, it may be a little more difficult because it's in Georgia, but
Do we know the release date, Jordan, of the prisoner? How long is he in the prison?
I don't know his release date. I know that he took a plea deal. I don't know the exact amount of time that he was given.
See, my concern, Judge, is that we go on with this process. We don't get his deposition. The trial comes up in May and he shows up live for trial.
I'm not going to do that to you, but
Okay.
you need, for you to get a continuance, you're going to need to force this situation and get a motion and compel on file to
Okay.
get the deposition done. And then if it turns out that we can't get done, but if you wait to the last minute and say, Judge, they never produced them, and I haven't had any chance to assert the court's authority to try to get this done, then I'm not giving you a continuance. Does that make sense?
That does make sense. I'll file the motion this week, Your Honor.
All right. You guys have a great rest of your day, okay?
Thank you.
Thank you
And
very
give
much.
me, if you haven't, did you submit an order on the summary judgment?
If I have not, Your Honor, I
Let
will.
me see.
Uh, are we off the record, Your Honor?
Yeah, let's go off.
Your Honor, I was gonna say, Your Honor, I was having similar issues last week, and I ended up calling Spectrum, and they had to just replace my router. Was the only thing that fixed it for me. I don't know if that helps you.
Go ahead.
I was saying, Your Honor,
That may be something I need to do. Yeah, I don't know what's going on. I've never had, we were doing fine until last night, and then things started happening, and
yeah.
anyway, but I appreciate that.
And I was gonna say, Jonathan, you can give me a call on the cell phone. I'll tell you, we try to work this out, and I'll try to call them today if you want for the deposition.
Okay.
Thank you.
Thank you.
May we be excused, Your Honor?
You may. You have a great rest of your day. Okay.
You too, Your Honor. Thank you.
Bye.
Next one, Wells Fargo Bank versus Sidney L. Berg. Cause number is DC 2402-166. Attorneys are Smart and Clark.
Good morning, Your Honor. Tom Sellers here on behalf of plaintiff.
Morning, Your Honor. Bob Clark on behalf of Sidney Berg.
All right. So I reviewed everything. Mr. Clark, you make quite a few arguments. What's your strongest one?
Well, they only filed a breach of contract claim, and they don't have a contract that's admissible. Sometimes judge when a case is really a dog case from the other side, I give it a name. This one I call the Tower of Babel. And I even cited Genesis in this. They have their contract in 7 different languages. The rules of evidence are clear. They need to have a transcription of what each of those things said. They even have in languages I hadn't heard of it, Talagi, which may be something to do with of the Philippines. They have a number of those. Secondly, she said each and
Is
every.
it not in English? It's only in other languages.
Well, no, it's mostly in English, but there are portions that are in 7 different languages, and those we don't know what those say. They could say this is really not an effective contract, or we don't know what they said, what they say. I don't think there's anybody at the courthouse that could speak 7 different languages.
Maybe Judge Ginsburg. You never know. He's pretty
Judge
bright,
Ginsburg?
yes.
Yeah, maybe he can speak. He's worried on admiralty
Maybe
law.
he speaks Talagi or whatever it is.
He's now getting an LLM in admiralty.
Doesn't surprise me. He's a very bright guy. All right.
Yeah.
Response?
Yes, Your Honor. The section that Mr. Clark's referring to, first of all, the section's in English, and then it has those other languages, but it's under the heading of Notice to California Cardholders. And it says to our California customers who have discussed credit card terms and conditions in Spanish, Chinese, Korean, Vietnamese, or Tagalog, read Part 6, Section 9 and the interpreter certificate. Then that section is also in English, followed by those languages. That's not applicable here. He references Rule of Evidence 1009. That's for a completely foreign language document. That's not what we have here. This is, as most credit card agreements are, Texas law is held. These boilerplate agreements are both admissible and proper evidence for summary judgments. But it is a boilerplate contract. California law requires these other additional interpreter certificates, but that has nothing to do with Mr. Clark's client. We're squarely in Dallas County, which is not in California. Mr. Clark has not made no reference to his client being at any time a California resident or a cardholder from California. Never does it state that he ever did anything in his agreement or in his affidavit that they discussed this in any language other than English, that he speaks any other language than English. In fact, the affidavit Mr. Clark's client the defendant put into their motion is in the English language. So that, despite his reference to Genesis, which I don't know is a proper legal reference, but the objection of 1009 is not proper here because that's not what type of contract we have. So that
Okay.
should be overruled, and this isn't a California dispute, so that portion of the contract's not really relevant, although the language is in English as well as those other languages, so it can be read by this court and all parties to this dispute.
Judge,
All right.
can I respond?
No, I'm gonna go ahead and grant the summary judgment. I don't think this applies. So, all right. Thank you guys. You have a great rest of your day, okay?
Your Honor, I think we submitted an order. Did it make, proposed judgment? Did it make it to your
It
queue?
did, and I just signed it and sent it in.
Thank you, Your Honor. May we be excused?
You may.
Thank you,
Anyone
everybody.
here on Discover Bank versus Hill?
Yes, Your Honor. Saeed Ahmed on behalf of Discover Bank.
Anyone else here? All right, Tony, let's go on the record on DC 24-14323, Discover Bank versus Hill. Counsel, make your appearance.
Your Honor, Saeed Ahmed on behalf of plaintiff, Discover Bank. Your Honor, we wanted to withdraw the motion for summary judgment in this case. And keep the next setting that's set on November 18 for a non-jury trial. We have settled, but we are just waiting on the paperwork in this case, but we don't want to remove the setting in November at this moment until we get the paperwork back.
Okay, you have a great rest of your day. No problem.
Thank you, Judge. Maybe.
You may be excused. Mr. Chu, Miss Wells, what did you guys figure out?
I'm just sitting here waiting, Your Honor.
Miss
She's
Wells?
making the phone call.
Yes, Your Honor. Yeah, I was able to talk to the interpreter, and they said that they are not available for tomorrow, but they are available next week, as early as the 3rd.
Okay, I have problems next week. I can do it this week. What can you go ahead and get them on the phone and let's talk to them, see if they can do anytime this week.
Okay. Is there a specific day that I should be asking?
Well, just get them on the phone. Let's talk to them.
Okay.
Hey, Rhonda, are you there?
Yes,
And-
Judge.
Can you, I'm sorry, I didn't mean to interrupt you. Go. Were you saying something?
No. Go ahead, Judge.
His screen is blank. I don't know if he got dropped again. Looks like he's back now.
I'm back. Yeah, okay. Did you hear that, Rhonda?
No, I didn't, Judge. Can you repeat?
Yeah, so I sent you an email about setting up a status conference on the other case that's still set for tomorrow.
Uh-huh.
I believe it's Hernandez versus Nonadim. Can you see if you can get them on the phone, get them on the Zoom, and so that we can talk to them about when they want to try their case?
I'll be right back.
All right, thanks. Okay, you have the interpreter on the phone?